Good morning, this is your Kelso Report for Wednesday, June 27th, and I'm your host, Clark Kelso. We begin with an environmental law case from the Ninth Circuit. In Snoqualmie Valley Preservation versus USACE, the Corps of Engineers, the Ninth Circuit affirmed the decision of the Corps of Engineers that a project modifying the dam at a hydroelectric power plant at the 268-foot-high Snoqualmie Falls in the state of Washington satisfied the requirements of one of the Corps' nationwide permits, which means the project does not require an individual permit and further environmental analysis. A group of downstream property owners sued, arguing that because there is a nationwide permit dealing with hydroelectric power plants that produce below 5,000 kilowatts, and the power plant at issue produces more than 5,000 kilowatts of power, it was inappropriate for the Corps to verify that the project satisfies several other nationwide permits that don't specifically address power plants. In other words, plaintiffs argued that the under 5,000 kilowatt permit is the exclusive basis for permitting the project, and it didn't apply. The Ninth Circuit rejected this stretched argument, holding that each of the Corps' nationwide permits stands on its own footing, and if the project satisfied a different nationwide permit, that was a sufficient basis for the project to move forward, since every nationwide permit had already undergone exhaustive environmental analysis. Next, you have a criminal law case involving tax evasion. The defendants in United States versus Meredith were convicted of conspiracy to defraud the United States, mail fraud, false representation of a Social Security number, passport fraud, and failure to file income tax returns. All of these in connection with their participation in businesses that helped customers evade federal and state income taxes. The defendants appealed, arguing that their convictions violated, of all things, the First Amendment. The Ninth Circuit rejected this argument. While it is true that mere advocacy of tax evasion and nothing more cannot support convictions for conspiracy or fraud, the evidence established that the defendants did far more than advocate. They actively helped clients hide their income from federal and state authorities through various improper means. That's not First Amendment activity, that's a ticket to jail. Next, we have a case involving school boards and agendas. School district board meetings can be pretty emotional forums for discussion of local issues. But you have to get on the agenda first. The petitioners in Mooney versus Garcia asked to be placed on the agenda an item which proposed to convert a Rainbow Day, which was scheduled at one middle school to promote anti-bullying awareness for gay, lesbian, bisexual, and transgendered students, into an all-inclusive anti-bullying day. Well, the request was denied on the ground that the proposed item was not within the board's subject matter jurisdiction because the board does not direct specific activities at individual schools. Well, instead of taking the hint, the disappointed parent filed a petition for a writ of mandate to try to force the superintendent to place the item on the agenda. Quite sensibly, the trial court denied the writ, and the 6th District affirmed, concluding that the statutes give school boards discretion to decide what items will be placed on a meeting agenda, and in particular, whether an item is within the board's jurisdiction. Since the board had discretion to decide that the petitioner's item was not within its jurisdiction, there was no basis for a writ of mandate, which, as we all know, can be issued only to command ministerial acts. That is, acts where the board does not have discretion. Well done, 6th District. Next, a case involving booking fees. The defendant in People v. Almanza complained that a booking fee of $415 was imposed upon him as part of his criminal sentence without regard to his inability to pay. This was a pretty easy case for the 4th District to resolve. It's just a matter of statutory interpretation. Government Code Section 29550.1 refers to persons who are arrested by an officer or agent of any city, special district, school district, community college district, college, university, or other local arresting agency. And it provides for imposition of a booking fee. A nearby provision, Section 29550.2, which applies to arrests by all other governmental entities, has statutory language expressly limiting its booking fee to persons who have the ability to pay. But Section 29550.1 omits that language. Now, since the defendant was arrested by a city police officer, he was clearly subject to a booking fee without regard to his ability to pay. The legislature knows how to add that language to point 1 if it chooses to do so. Finally, a workers' compensation case. In Meeks Building Center versus Workers' Comp Appeals Board, the employer argued that payment of costs to permit an injured worker to undergo a medical examination in an attempt to resolve a claim did not trigger the 2-year statutory period during which an employee may also receive temporary disability benefits while his or her claim is being resolved. The 3rd District rejected the argument that the 2-year period was triggered, explaining that there is a very clear difference between temporary disability benefits, which are intended to be a substitute for wages during a period of disability while a workers' comp claim is being processed, and the reimbursement of costs associated with undergoing a medical examination, which is a distinct type of medical legal benefits. In short, medical legal expenses are litigation expenses for the purpose of resolving a contested claim, not substitute wages during a period of incapacity. And therefore, when you have to pay those litigation expenses, the 2-year period for receiving temporary disability benefits is not triggered. And that's it for today's Kelso Report. Have a great day in the law.